Ever looked at your electricity bill and felt that familiar pang of confusion, all those extra charges or surcharges that seem to just materialize out of thin air? You are definitely not alone. It can feel like you're trying to decipher some kind of secret code, Adds this unnecessary layer of frustration when you're just trying to manage household or business expenses.
It really is a universal pain point, isn't it? That feeling of, well, powerlessness when you can't quite grasp what you're paying for beyond the basic kilowatt hours you used.
Absolutely. Well, today we're diving into a really groundbreaking June 2025 ruling from the European Court of Justice. We'll just call it the ECJ for short. And it directly cuts through some of that confusion. This deep dive is all about how taxes on electricity are regulated within the EU and, maybe more importantly, what this specific legal decision means for you, the consumer. Our mission really is to take this complex ruling and translate it into clarity, show you why it's potentially a game changer for your wallet and your rights. Okay, let's unpack this.
Right. And every significant legal battle usually starts somewhere quite specific, often with a very frustrated customer. In this particular case, that spark, so to speak, was ignited in Italy. It involved a company named Falconeri Srl. They were challenging their electricity supplier, a company called Hera Comm SpA. Basically, Falconeri believed an additional tax on their electricity bills had been wrongly charged, and, well, they wanted a refund.
Okay, so this wasn't just a general grumble about high prices. It was a direct challenge to a specific Italian additional tax. Can you tell us a bit more about this particular tax? Where did it come from and how did it work?
Certainly, this additional tax actually came into being through an Italian decree law, number 511988. And it was enforced for quite a long time, actually, until it was repealed back in April 2012. Its official stated purpose, right there in the preamble of the decree, was, I'm quoting roughly here, to secure the resources necessary for the finances of regional and local authorities, basically to help them carry out their tasks.
Okay, so the idea, on paper at least, was to help fund local governments. How did it actually show up on people's bills? How was it collected?
It was levied on top of the standard excise duty on electricity, so an extra layer. The rates varied too, depending on usage. For example, there were different amounts per 1,000 kilowatters for, say, dwellings versus second homes or commercial places. And critically, the revenue from this additional tax, was earmarked to go directly to local or regional authorities. That's quite different from the regular excise duty, which just went into the main Italian treasury pot. Hera Comm, the supplier in this case, collected this tax from its customers, like Falconeri, and then passed it on.
In Falconeri's core argument, their challenge was that this whole setup, this additional tax, actually flew in the face of existing EU law. That sounds like a pretty bold claim to make, taking it all the way to the European Court.
It was, absolutely. And it hinged entirely on the specifics of the broader EU framework for energy taxation.
Which brings us neatly to the EU law itself. And this is where this concept of specific purposes becomes absolutely vital, doesn't it? It's almost like the secret handshake for whether these extra kinds of taxes are legitimate or not.
Indeed, that's a good way to put it. The EU has a couple of core legal rulebooks for energy taxation. You can think of them as, well, the overarching guide for how taxes on goods like electricity generally work. That's Council Directive 2008-180-TC. And then there's a more specific one, Directive 2003-96-EC, which aims to harmonize electricity taxation specifically across all the member states. These aren't just suggestions, they're legal mandates.
Right. Now, there's a key clause in that first directive, Article 1.2 of 2008-118, and that seems to be the heart of the matter here. It says something like, okay, member states, you can levy other indirect taxes on top of the standard ones for excise goods, like electricity. But, and this is the crucial catch, right? You can only do this if these taxes are for specific purposes. And they still have to follow EU rules on things like how the tax base is calculated. But interestingly, they don't necessarily have to follow the same exemption rules as the standard excise duty.
Exactly. So the Italian court, faced with Falconeri's challenge, basically turned to the ECJ and asked a critical question. Was this additional Italian tax a genuinely distinct other indirect tax, which would mean it needed that specific purpose justification, or was it in reality just a sneaky way of charging a higher rate of the existing harmonized excise duty? Because if it was just a rate increase, it wouldn't need that separate specific purpose.
And the court's ruling on this was, as you said, a real clarification, a kind of aha moment. They decided the Italian additional tax was indeed an other indirect tax, separate from the main excise duty. Why was making that distinction so important?
Well, the ECJ essentially looked under the hood, didn't they? The first big giveaway, the first reason this wasn't just a simple rate hike, was the different destinations for the revenue. As we mentioned, the standard electricity tax went into Italy's national treasury, the big pot. But this additional tax, that was specifically channeled to local and regional authorities.
Ah, okay, so not the central government fund.
Exactly. That's a clear indicator it's operating differently. It's like finding out part of your income tax was going directly to your town council. You'd know something different was happening.
Okay, so the money going to different places was clue number one. What else raised red flags for the court?
Second, the tax had differentiated rules. The Italian law allowed for different rates based on very specific criteria, the type of use, where the electricity was supplied, even the quantity consumed. These sorts of differentiations are simply not allowed for the standard harmonized excise duty under EU law. If it were merely an increase in the existing tax, it should really have applied more uniformly, without all these special carve-outs and conditions.
Right, should follow the same basic structure. And the third reason, you mentioned exemptions earlier. Was that part of it?
That was perhaps the most critical point, yes, the crucial discrepancy regarding exemptions. So even though this additional tax was calculated and collected in a way that looked quite similar to the standard excise duty, it did not follow the same exemption rules that are laid down by EU law for that standard excise duty. For instance, EU law mandates exemptions for certain electricity uses, like for running railway lines, or electricity used just to maintain the capacity to produce more electricity. But these mandatory EU exemptions didn't apply to the Italian additional tax.
Ah, I see. So if it walks like an excise duty increase and quacks like one, it still has to follow all the excise duty rules, including the exemptions.
Precisely. If it were truly just a higher rate integrated into the existing excise duty system, it absolutely should have mirrored the exact same exemptions. The fact that it didn't was a huge tell.
A fundamental mismatch. Okay, and then there's a specific purpose justification itself. What did the court say about Italy's stated reason for the tax funding local authorities? Did that count as specific?
No, it didn't. And this is crucial. The stated objective, securing resources necessary for the finances of regional and local authorities. The court deemed that to be a purely general budgetary purpose, just funding the government, essentially. And that doesn't qualify as a specific purpose under the directive. A specific purpose, in the eyes of EU law, needs to have a clear, non-budgetary policy objective. Think environmental protection, or public health initiatives, or maybe funding a very defined infrastructure project. Simply allocating money to general public spending, however important that spending might be, just doesn't meet the test. The CJEU basically said you can't just relabel general revenue collection to get around the harmonized tax rules.
So, boiling it all down, the Italian tax was deemed unlawful under EU law because it was structured as an other indirect tax, but lacked the necessary, genuine, specific purpose required by the EU directive.
That's the core of the first part of the ruling, yes. It really tightened the definition and made clear the very strict conditions under which member states can legitimately impose these kinds of additional taxes on energy.
Okay, now this leads us to the really crucial part for you, the listener, the consumer, your rights and what you can actually do about it. Can you get a refund for these unlawfully charged taxes? The Italian court asked a vital question here, didn't it? About something called horizontal direct effect. Sounds complicated.
It is a bit of a legal mouthful, but it's very important in practice. Let's break it down. Normally, an EU directive sets rules for governments. If your government breaks an EU rule that affects you, you can usually rely on that EU rule in your national court when challenging the government or a state body. That's vertical direct effect. But horizontal direct effect asks a different question. Can you, a private individual or a private company like Falconeri, use that same EU rule, which was aimed at the government, to directly sue another private party, like the supplier Hera Comm, in a national court to get your money back?
Okay, so using an EU rule meant for the state directly against a private company.
Exactly. And the general answer usually is no. EU directives are typically not considered to have horizontal direct effect. A national court isn't required by EU law alone to just ignore a national law, simply because it conflicts with an EU directive in a dispute purely between two private parties.
Right, so if I'm just a regular person hearing that, it might sound like, okay, the tax was illegal, but my EU rights don't help me get the money back from the private company that charged me. That feels like a potential dead end. But the ECJ offered some ways around this, didn't it? How does it ensure consumers aren't just left high and dry? This is where it gets really interesting for you listening.
Absolutely. The court provided crucial nuances, consumer-friendly lifelines, if you will. Firstly, even if EU law doesn't directly force the issue between two private parties, your national law might still provide a way. Your own country's legal system might have principles of restitution or unjust enrichment that allow you to make such a claim against your supplier for passing on an unlawful charge. So always check your national options first.
Okay, that's a good first possibility. Rely on domestic law. What else? Does the nature of the supplier matter?
Yes, it can. Secondly, the ECJ clarifies that if the electricity supplier isn't just any private company, but is subject to state control or possesses special public powers, think perhaps of a state-owned utility or a company granted specific public service obligations by the state. Then, in that situation, the directive can be relied upon directly against them, even if they look like a private company on the surface. The national court has to investigate the supplier's specific status.
Right, so if the supplier is kind of an arm of the state, the EU rules apply more directly, and then what's the ultimate safety net, the backstop for the consumer?
This is the most important guarantee, really. The ECJ stated that if it proves impossible or excessively difficult for you, the final consumer, to get reimbursement of the unlawfully paid tax from your supplier, then EU law requires that member states must ensure you have an effective way to direct your application for reimbursement directly to the member state itself. This is a critical safeguard. It means the buck ultimately stops with the state that implemented the unlawful tax in the first place. You shouldn't be left out of pocket because of procedural hurdles between private parties.
That's really powerful. So even if chasing the supplier is too hard or impossible, you have a direct line to claim it back from the government whose illegal tax it was. It strongly upholds that principle. Illegally collected taxes must, one way or another, be reimbursed.
Exactly. It puts the onus back on the state to ensure rights are effective. It's a crucial line in the sand drawn by the court.
So let's zoom out again, connecting all this back to the broader picture. What does this June 2025 ruling actually mean for your electricity bill day to day, moving forward across the EU?
Well, I think this ruling marks a significant turning point for transparency in energy billing. It essentially confirms very clearly that member states can only add these kinds of extra charges, these other indirect taxes, onto electricity bills in very specific situations that meet strict criteria. This should mean, hopefully, an end to vague or random administrative fees or unexplained network surcharges unless they're absolutely crystal clear, legally justified under the specific purpose rules, and meet all the EU standards.
That sounds like a definite move towards much clearer bills and hopefully fairer charges. Fewer of those mystery line items we all dread.
That's certainly the intention and the likely effect, yes. Governments now have the burden of proving that any extra charges they allow or impose actually align with the narrow exceptions permitted by EU law, those unclear blanket fees. They're now effectively off the table and vulnerable to legal challenge based on this precedent. For you, the consumer, this should translate into fewer confusing mystery charges on your monthly bills. It should also make it easier for you to check if the charges comply with indirect tax regulations. And for businesses, particularly small, medium ones, being able to predict energy costs with more confidence is a huge benefit.
And it definitely strengthens your hand when it comes to getting your money back if something is wrong, right?
Yeah.
This extended refund entitlements.
Significantly, yes. The ruling bolsters your refund rights considerably. If you've paid charges that look like these unlawful additional taxes, particularly since the ruling clarified the rules so starkly, or even if you spot them looking back at older bills now with this knowledge, you now have a much clearer legal basis and pathway to claim a refund. The rules, as interpreted by the ECJ, are now firmly on your side in challenging improperly justified extra charges.
Okay, so given this new landscape, this clearer picture, what are the practical steps people can take right now? What should we all be doing when that electricity bill lands on the doormat or in the inbox?
Right. Practicalities, first and foremost, and this is basic but crucial. Keep all your electricity bills and any payment records. Treat them like important financial documents, because they are. Documentation is absolutely key if you need to make a challenge later.
Makes total sense. Get your paperwork in order, and when you actually receive the bill, don't just glance at the final amount owing.
Precisely. Question everything. Take a moment. Compare your current bill to previous ones. Look for changes. If you see any new charges or line items with vague descriptions or unexplained add-ons, question it right away. Contact your provider and ask for a clear, written explanation for any extra charges you don't understand. Get it in writing. This creates a record and forces them to justify the charge.
Good advice. Create that paper trail. And what if you do spot something that looks genuinely questionable or just plain wrong based on what we've discussed?
If you identify what looks like an unauthorized surcharge, maybe something labeled miscellaneous or additional regional fee without proper justification, or perhaps a wrong VAT rate being applied, then file a refund claim directly with your supplier first. State your case clearly, referring to the need for proper legal justification for charges beyond standard supply and regulated network costs. Don't be intimidated. If they're uncooperative, dismissive, or unresponsive, then escalate it. Take your complaint to your national energy regulator or your local consumer protection agency. They exist to help enforce these kinds of rules.
Could you maybe give us a quick sort of red flag checklist, specific things to look for on our bills?
Sure, a quick rundown. Your standard supply charge, per kilowatt hour rate, plus standing charge. Yes, this is obviously allowed, and VAT applies. No action needed here usually. A regulated government fee, like a green levy or similar. This might sometimes be allowed, provided it meets the specific purpose test we discussed or is part of the harmonized structure. VAT likely applies. For these, it's always fair to ask for the specific legal reference backing the charge. They should provide it. A miscellaneous surcharge or administrative fee. This is rarely allowed unless explicitly tied to a specific service you requested. If it's just a general add-on, VAT might apply, but the charge itself is a major red flag. Challenge or dispute this immediately. And charges for network maintenance or grid costs. These are generally allowed as they relate to the physical delivery, but only if they are legally justified and reflect regulated network tariffs. VAT applies. If the amounts seem excessive or unclear, request a full breakdown and the precise legal basis for how they are calculated. Don't accept vague explanations.
That's really helpful, thank you. It feels like this June 2025 ruling ultimately gives you, the consumer, significantly more control, or at least more power to demand control, over your energy bills and the associated VAT costs. By understanding these newly clarified strict limits on additional charges, and by knowing your refund rights are stronger, you're much better equipped to spot unfair charges quickly and, well, ensure you're only paying what's legally compliant.
Absolutely. And I think this deep dive into what might seem like a very specific EU tax case from Italy really demonstrates something broader. It shows how these foundational principles of EU law, things like needing a specific purpose for certain taxes or the complex nuances of direct effect, aren't just abstract legal theory. They can have a very real, very tangible impact on your everyday expenses, on your wallet.
It really makes you wonder, doesn't it? Thinking beyond just electricity bills, what other charges might be lurking on our daily bills? From various services, phone bills, insurance, maybe even bank charges. How many times have we maybe just scrolled past a vague service charge or regulatory fee without a second thought? What else might we be paying for day in, day out that perhaps wouldn't stand up to similar scrutiny if we really looked closely?
It's a valid question. The principles of transparency, justification, and fairness in charging should ideally apply much more broadly. This ruling certainly provides food for thought and perhaps a precedent for looking harder.
Well, we hope this deep dive has helped you feel more informed and, crucially, more empowered when it comes to understanding your energy costs. Thanks for tuning in to The Deep Dive.